treaties that's ever been drafted in international law in terms of the independence of the prosecutor, independence of the judges, the advances in gender crimes, and I could go on for all time. It does not hold states responsible for crimes. It holds individuals responsible for crimes. And the governments picked initially the 3 crimes which almost all of the governments had ratified in international humanitarian law: war crimes, crimes against humanity, and genocide. Crimes of the Genocide Convention, of the Geneva Conventions, and in terms of crimes against humanity, customary international law. And again, it holds the individual responsible. So when the governments in Rome listed the crime of aggression, it would be following the same track. It wouldn't be holding a state responsible, but it would be holding an individual responsible for a crime. In this instance, unlike the other crimes, the crime of aggression has to be committed by a state. It's a state act. The definition that was agreed to in Kampala is, for the purpose of this statute, the crime of aggression means the planning, preparation, initiation, or execution by a person in position effectively to exercise control over or to direct the political or military action of a state, of an act of aggression which by its character, gravity, scale constitutes a manifest violation of the state. The second paragraph describes the act of aggression. Again, means the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the UN. And then it describes specifically invasion or attack by armed forces of a state, a territory of another state, or military occupation, however temporary, bombardment by armed forces of a state against the territory of another state, blockade of ports or coasts of a state by armed forces of another state, the attack by armed forces of a state on the land, sea, or air, etc.
So this interrupt you for just a second. When you were reading the definition, I happened to hear that you used the words a manifest violation. And I remember that Ben mentioned this morning that there had been a huge debate for a long period of time about whether to use the word manifest or egregious. And I think the first of all the compromises that comes out of Kampala is the insertion of the word manifest. Can you explain why that was put in there and what or it's intended to be?
I think that there could be, that the governments wanted some qualification of the term violation of the UN Charter, wanted to have a term like manifest so that it was, in their mind, meaning that this is a violation that was contrary to a decision of the Security Council, or inconsistent with the Security Council resolutions, or inconsistent with the Charter. It wasn't kind of a neutral manifest violation, but it was a egregious, if you wish.
So just like not all war crimes are covered by the ICC statute,
right.
Just those part of the policy plan, not all acts of aggression, but just those that are particularly egregious or something that meet this manifest definition. And this was so that a case like I described, the bombing in 1999 of the former Yugoslavia for humanitarian reasons, might not be covered. Right. Okay.
So in this compromise, the definition and the individual responsibility language has been agreed to by a unanimous agreement, that is a consensus agreement of the governments, the state parties in Kampala. No country objected. And in the room were all of the permanent 5 members, plus the Indias, Pakistans, Egypts, all the countries, which is one of the most significant things to note about this. The second aspect of the definition then was how would the court exercise jurisdiction? And essentially the compromise that was agreed to was that if a country referred a matter, or if there was a belief that aggression had occurred, the prosecutor would write to the Security Council and ask the Security Council if they have determined whether an act of aggression had occurred. If the Security Council said yes and referred a matter to the court, or if they had, without the prosecutor or anyone doing anything, referred what they considered an act of aggression to the court, then the court would have jurisdiction.
And this would be over both parties to the statute and also non-parties, right?
The Chapter 7
Right.
power applies to members of the United Nations. So any state that is a member of the United Nations has to submit to the authority of Chapter 7 authority. If the council didn't act within 6 months, then the prosecutor could go to the pretrial chamber of the ICC and make the case that an act of aggression has occurred and that she or he has evidence of a crime of aggression. And if the pretrial chamber could make a decision then on whether the prosecutor had the evidence or didn't have the evidence. And as you've heard in testimony in the previous panel, sometimes the judges have said the prosecutor had the evidence, and sometimes they've said the prosecutor didn't have the evidence. So it is an independent court. It has been demonstrated.
And Bill, if we consider this then two tracks, the Security Council referral track and this prosecutor going to the court and independent court track, which countries does the independent court track apply to?
Well, I need to qualify one more time. Now, even if the pretrial chamber approves and the prosecutors to go forward, still the Security Council would have another bite at the apple in terms of adopting a resolution under Article 16 that says, don't go forward with this at all. So there's a number of checks and balances over the court being exercising jurisdiction. Now then, in addition, the treaty that was agreed to in Rome will treat this fourth crime very differently than it will treat the war crimes against humanity, and genocide. In those three crimes, once a government ratifies the treaty, they accept the jurisdiction of the court for those crimes when their nationals committed or when the crime is committed on their territories. On the crime of aggression, it is quite a mess, if you wish, of those principles. So that first, a state party that files a declaration saying they do not want to accept the jurisdiction of aggression, that is this amendment, therefore their nationals and their territory would not be subject to the jurisdiction of the court.
So countries can opt out.
Countries can opt out, but opt out plus, because they not only are able to opt out, but if their nationals commit aggression on another country's territory, because they're a national of a state party and they've opted out, the court would not have jurisdiction even in a situation like that. Then secondly, non-state parties, which are barely mentioned in the Rome Statute, in this amendment have been given tremendous attention, and so that a government that is not a state party to the Rome Statute, its nationals and its territories are exempt from the jurisdiction of the court, with again the caveat, except when the Security Council would refer a matter.
So, for example, if the United States were to be accused of committing crimes against humanity in the territory of the state party, like Afghanistan, even though the U.S. is a non-state party, its officers can be tried, can be prosecuted. But if the accusation is for the crime of aggression, doesn't apply at all to non-state parties, no matter where they commit their crimes.
That's correct.
Okay.
So one or two other provisions here is that the governments agreed that they would not proceed with this jurisdiction until after January 1st, 2017. And at that point, 2/3 vote and agree to turn on this jurisdiction.